Imagine a law is passed today, but it's locked away in a drawer in the president's office.
Oh, wow.
Yeah, literally nobody knows it exists. And then tomorrow, you're just walking down the street and you are suddenly arrested for breaking it.
Right, which sounds completely insane.
It sounds like the plot of a dystopian novel, right?
Mhm.
But the thing is, in 1985, this exact scenario forced the Philippine Supreme Court to answer a pretty terrifying question, which is a secret law actually a law at all?
Right, the classic Tañada case.
Exactly. So if you are studying for your law exams right now and looking for, that extra edge to truly understand the mechanics of cases like this, you are in the right place. We are breaking down the friction between constitutional theory and reality today.
Yeah, we really are.
And hey, if you want more insights after we wrap up this deep dive, make sure to subscribe and definitely check out the Free Bar Coaching website. Tons of amazing free law materials.
Highly recommend doing that. And honestly, this Tañada scenario is just the perfect starting point for our deep dive today.
It really sets the stage.
It does, because we are looking at a stack of sources that map out the absolute bedrock of the Philippine legal system.
Right. Let's give you guys the overview of the sources we're tackling.
Sure. So we have excerpts from the 1987 Philippine Constitution, the Ombudsman's Handbook for Teachers. There's a Houston Law Review article on the rule of law, and obviously foundational jurisprudence like the 1985 Tañada v. Tuvera case we just mentioned.
Plus an analysis from Respicio and Company on equal protection.
Yes, and finally, to ground it all in the present day, we're looking at the Human Rights Watch World Report for 2026.
Right, so the mission here for this deep dive is to bridge that gap between what you read in your textbooks and what actually happens on the street.
Because it's not always a one-to-one translation.
Exactly. We aren't just going to list legal doctrines for you to memorize. I mean, you can read a syllabus for that. We need to look under the hood and analyze how the machinery of justice actually operates.
And sometimes how it completely breaks down.
Yeah, sadly. But to understand the machinery, we really have to start with the concept that powers the entire Constitution, right?
Right. The rule of law. The Houston Law Review and the Ombudsman Handbook both root the Philippine legal framework in this very old idea from Aristotle.
The government by laws and not by men concept.
Exactly. But what the Houston Law Review does brilliantly is it splits this concept into two distinct mechanisms. You have the rule of law as a procedural ideal, and also as a substantive ideal.
Okay, let's break those mechanisms down for everyone listening. So procedural would mean the actual steps, right? Like the mechanics of how a law is made and applied.
Correct. Procedurally, the machinery demands that laws must be publicly promulgated. They have to be equally enforced across the board and independently adjudicated by the courts.
Okay, got it.
But then the substantive ideal, well, that looks at the soul of the law, I guess you could say.
Substantive is always the tricky part for students.
Yeah, because substantively, a perfectly passed law like procedurally flawless is still totally invalid if it doesn't protect fundamental human rights or if it lacks inherent justice.
I always look at this through the lens of a basic contract, which, any law student is painfully familiar with at this point.
Oh, the dreaded contracts class.
Right. So imagine signing a contract where one party just inserts a clause allowing them to unilaterally change the terms of the agreement at any point.
Without telling you.
Exactly, without telling you, based entirely on their mood. In contract law, that makes the agreement illusory.
Right, it's void.
And in constitutional law, that is the rule of man. It's governance based on whim and bias. So mechanically speaking, how does the Philippine Constitution prevent the state from treating citizens like subjects to an illusory contract?
Well, it anchors the entire system in Article 2, Section 1 of the 1987 Constitution. It explicitly states, sovereignty resides in the people and all government authority emanates from them.
Which is a massive paradigm shift from the rule of man.
Huge. It means the state does not have inherent power. It only holds power because the citizens delegated it to them.
Right.
And to ensure the state doesn't just turn around and abuse that delegated authority, the framers built in what the ancient Greeks called isonomia.
Isonomia. Equality under the law.
Precisely.
And mechanically, that's the function of the Bill of Rights in Article 3, right?
Yeah.
I mean, it isn't just a list of nice ideas or suggestions.
Far from it. The Ombudsman Handbook actually illustrates this vividly. The Bill of Rights is a structural protective shield.
Okay.
When the state's police power, or say its eminent domain, gets way too aggressive, the Bill of Rights acts as a hard boundary. It is the ultimate mechanical check against the rule of man.
Which, okay, That brings us right back to that dystopian scenario of the secret laws locked in a drawer.
Ah, yes, Tañada.
Yeah, because if the state is going to exercise its delegated power to regulate behavior, it has to fulfill its end of the social contract. And the absolute baseline procedural requirement for that is notice.
Notice is the heartbeat of due process. You just can't have due process without it. And in Philippine jurisprudence, we see the mechanics of this play out perfectly in that landmark 1985 case, Tañada v. Tuvera.
Right. So let's set the historical stage for the listener here so they can really visualize the exam question.
Good idea.
It's 1985. The president at the time was issuing presidential decrees, letters of instruction, general orders, essentially. The executive branch was churning out legislation on its own.
Right, circumventing the normal legislative process.
Exactly. But the problem was, the petitioners in this case realized that many of these issuances were never actually published anywhere.
They were just phantom laws.
Phantom laws, which is terrifying.
Totally. So the petitioners filed for a writ of mandamus. They were asking the Supreme Court to compel the government to fulfill what they argued was a ministerial duty.
Meaning they had no choice but to do it.
Exactly. They had to publish these decrees in the official Gazette so the public could actually see them. They invoked the people's constitutional right to be informed on matters of public concern.
Okay, but let me push back here and play devil's advocate for a second, because I know a sharp law student analyzing the civil code will spot a loophole here.
Okay, let's hear it.
So, Article 2 of the Civil Code states that laws take effect 15 days following the completion of their publication in the official Gazette, quote, unless it is otherwise provided.
Right. That famous little clause.
Yeah. So if the executive branch drafts a presidential decree and slaps a clause at the bottom stating, this decree shall take effect immediately, hasn't the lawmaking body simply exercised its power to provide otherwise?
That's the logical argument, sure.
Why doesn't that legally bypass the publication rule entirely?
Well, you've actually just voiced the exact defense mounted by the respondents in the case.
Oh, really?
Yeah, they argued that the unless otherwise provided clause gave the executive an out.
So why didn't the court buy it?
Because Justice Escalin's ruling dissects why that logic fundamentally fractures the rule of law. He points out that interpreting the civil code in that manner conflates two entirely different legal concepts: the date of effectivity and the fact of publication.
Oh, I see. So a law can say it takes effect immediately upon publication, but it cannot say it takes effect without publication.
Precisely. Because if you remove publication completely, you collide with one of the harshest foundational maxims in law, which is ignorantia legis non excusat.
Ignorance of the law excuses no one.
Right. The legal system relies on this harsh rule because if ignorance were an excuse, literally every single defendant would claim they didn't know the law.
I didn't know I couldn't do that, officer.
Exactly, and the justice system would just collapse overnight.
But the only way a society can ethically enforce such an unforgiving rule is if the state actually makes the laws knowable in the first place.
And Justice Escalin recognized that structural necessity. He ruled it would be the, quote, height of injustice to punish or burden a citizen for violating a law they had absolutely no way of discovering.
It's just fundamentally unfair.
Right. So due process mechanically demands that before a person's liberty or property is restricted by a law, they must be officially informed of its contents.
Therefore, those unpublished presidential issuances simply had no binding force. They were void.
Absolutely void.
You know, reading the source material for this case, the concurring opinions are just as fascinating to me.
Oh, yeah. There's a really interesting debate in there.
Yeah, because they debate the actual mechanics of how this notice must happen. Justices Plana, Fernando, and T. Hankey completely agreed that secret laws are void.
They were unanimous on that.
Right, but they debated the rigidness of the official Gazette requirements specifically.
It's a brilliant debate about statutory construction versus constitutional guarantees, really.
Oh, so.
Well, Justice Plana argued that while due process demands public notice, the Constitution itself doesn't explicitly force that notice into the official Gazette.
Oh, so they could use a newspaper instead.
Exactly. If a law specifies a different mode of broad public notice, say, publication in a newspaper of general circulation that might constitutionally suffice to inform the public, the method can vary, but the fact of notice is absolute.
Okay, so we've established that a secret law is no law at all. The state fulfills its duty, publishes the decree, and everyone is on notice.
Right. Step one is complete.
But notice doesn't guarantee fairness, right? I mean, what happens when that perfectly published law says that citizens from Manila pay a 10% tax, but citizens from Cebu pay 30%?
Well, then you have a major problem.
Yeah, notice is achieved, but equality is completely shattered.
And that friction takes us directly into the Equal Protection Clause. Article 3, Section 1 states, "Nor shall any person be denied the equal protection of the laws."
But equal protection doesn't mean identical treatment, does it?
No, it doesn't, and that's a common misconception. Constitutional equality does not mean the legislature must treat every single human being identically in every conceivable circumstance.
Because that would be impossible to govern.
Right, the machinery of government actually requires the ability to categorize people. And this brings us to the doctrine of reasonable classification.
Okay, the Respicio and Company analysis provides a really strict four-part mechanism for how the courts measure whether a classification is reasonable or if it violates the Constitution.
This is crucial for students to memorize.
Listener, this is pure exam gold. Pay attention here. If a law creates a classification, the state must prove four things. Let's list them out.
Okay, first, the classification must rest on a substantial distinction.
Meaning a real factual difference.
Exactly. There has to be a genuine difference between the groups being classified. Second, that distinction must be germane or directly relevant to the purpose of the law.
Right.
Third, it cannot be limited to existing conditions only. It has to apply dynamically to future conditions too.
Okay, and then the fourth one.
And fourth, it must apply equally to all members of the same class.
Got it. Let's unpack the mechanics of this using the case of Ichong v. Hernandez.
Great example.
The sources point to this as a classic example of an invalid classification. In this case, we're dealing with the Retail Trade Nationalization Law, which essentially singled out alien residents and restricted their ability to engage in the retail trade industry.
Yeah, a very controversial law.
So why does a law like this fail the test?
Well, when the court measures a law like that against the four requisites we just mentioned, the machinery basically jams at the very first step.
At substantial distinction.
Yes. The state has to prove that there is a factual inherent difference between a Filipino retailer and an alien resident retailer that justifies stripping the alien resident of their livelihood.
Which is a heavy burden.
It is. And when the court examines the mechanics of the retail trade, it finds that citizenship does not inherently dictate one's ability to sell goods fairly or contribute to the local economy.
And because that distinction isn't substantial, the classification becomes entirely arbitrary.
Exactly.
It fails to be germane to the purpose of regulating trade, and therefore it violates the Equal Protection Clause. Boom.
But, and this is a big but, the courts don't just use a single generalized test to measure these violations.
Right, there are levels to this.
Yes, the level of scrutiny the Supreme Court applies actually shifts depending on who is being classified and what right is being restricted. Law students really need to understand the mechanics of the three tiers of judicial scrutiny.
Let's go through them. The default setting is the rational basis test, right?
Yes. For standard economic or social legislation, the court applies rational basis. And here, the burden of proof is actually on the challenger.
Wait, really?
Yeah, you have to prove to the court that the legislature's classification is completely irrational. It's a tough hill to climb.
But then the gears shift with intermediate scrutiny.
Right. Under intermediate scrutiny, the burden flips. Now, the government must step up and prove that the classification serves an important government interest.
Okay, like in the Central Bank Employees Association case.
Perfect example. The court had to carefully weigh the political activities of bank employees against the state's interest in maintaining a neutral banking sector.
Gotcha. And finally, the highest threshold, strict scrutiny.
The big one.
This is used for suspect classifications like race, or when a fundamental right, like free speech, is restricted.
Yes. And under strict scrutiny, the government must prove it has a compelling state interest and that the law is narrowly tailored to achieve it.
Which brings us to Estrada v. Sandigan-Bayan, dealing with the anti-plunder law.
Yes. The classification of plunder as a heinous crime triggers strict scrutiny, but the court found that the state has an overwhelmingly compelling interest in preventing the systemic looting of the public treasury.
The magnitude of the threat justify the classification.
Exactly.
You know, when you explain it like that, it sounds like the Supreme Court holds all the cards. They can just strike down laws passed by the elected legislature using these mathematical scrutiny tests.
It does seem that way sometimes.
To a layperson, this cause of judicial supremacy sounds like the court is just ruling over the other branches like a king.
The term is definitely provocative, but the landmark case, Angara v. Electoral Commission, demystifies how it actually works. The court isn't acting as a superior overlord here.
Now, what are they doing?
In a system of separated powers, boundaries inevitably clash. The legislature might pass a law that accidentally or intentionally bleeds into executive power or violates constitutional rights.
Right.
So when the Supreme Court strikes down a law like they did in People v. Vera with the Probation Act, they are simply fulfilling their sworn mechanical duty to act as the umpire. They're just allocating constitutional boundaries.
The umpire calling balls and strikes.
Exactly.
Okay, so let's take a breath and pivot here, because here's where it gets really interesting and honestly a bit heavy.
Yeah, this next part is tough.
We've talked about the pristine theory of the Constitution, but how does this hold up in the real world right now for you and your fellow citizens?
That's the real test.
I want to be very clear to our listener here. Looking at the 2026 Human Rights Watch report, our goal today isn't to take a political stance. We are not endorsing any political side. We are simply holding these documented findings up against the pristine constitutional theory we just discussed, completely objectively, based on what the source material says.
Right, because this is where the textbook hits the pavement.
What does the report actually say?
Well, the report lays bare a landscape where the procedural rules we've discussed are functioning, but the substantive outcomes are deeply fractured.
Give me an example of that.
For instance, on the front of accountability, the report documents the historic March 2025 arrest of former President Rodrigo Duterte and his transfer to the International Criminal Court in The Hague concerning extrajudicial killings.
I mean, that sounds like the machinery of justice working on a global scale.
On paper, yes. But simultaneously, the report notes that the violence hasn't stopped. The monitoring group DAHAS tracked 238 drug war-related killings in 2025 alone.
238. Wow.
Yeah.
So we have the constitutional guarantee of due process, yet we see targeted violence.
Exactly. The report also highlights violence against journalists. 3 were killed in 2025, according to the source. Juan Dayang, Erwin Labatad Segovia, and Noel Belen Samar. Activists also face severe red tagging.
And we also have to look at the mechanics of what the report calls legal weaponization, right? Because this is crucial for law students to understand.
Highly crucial. Because how do you silence civil society without openly violating the procedural rule of law? You weaponize existing statutes.
How does that actually work in practice? Like mechanically?
Well, according to the report, the state uses anti-money laundering and terrorism financing laws to freeze the bank accounts of activist groups or NGOs.
Oh, I see.
Procedurally, a law is applied, but substantively, it immediately cripples the organization's ability to operate, defend themselves, or advocate.
So it bypasses standard criminal due process where they would normally have a chance to face their accusers in court.
Exactly. And the irony highlighted by the report is that this abuse continued even after the Philippines was officially removed from the Financial Action Task Force's gray list in February 2025.
So the international compliance box was checked, but the domestic reality actually worsened.
Right. It's a perfect example of procedural compliance masking substantive failure.
And the report points to similar substantive gaps for marginalized groups too, right?
It does. The Philippines remains without divorce laws. The report highlights an absolute abortion ban despite a documented 58% increase in pregnancies among girls aged 10 to 14.
That's a staggering statistic.
And Congress has repeatedly failed to pass anti-discrimination legislation protecting the LGBT community. So equal protection isn't reaching everyone.
We also see the friction in Palawan regarding indigenous rights in the report.
Yes, a major issue. Indigenous peoples have pending ancestral domain claims, which are legally recognized rights.
Yet, they face forced evictions.
Right, to make way for an ecotourism project by the San Miguel Corporation. The procedural legal avenues exist, but the substantive protection of their fundamental property and cultural rights is failing.
So if the Constitution absolutely guarantees due process and equal protection, but activists disappear, like indigenous leader Janasca Enriquez and Michelle Campos, and ancestral domains are ignored, why study the theory at all?
It's a fair question.
Is the rule of law just an academic fantasy?
That is the existential question literally every law student faces at some point. But if we pull back to the Houston Law Review text, it explicitly admits that no country on earth claims perfect adherence to the rule of law.
Nobody has a perfect system.
Right. The article describes the rule of law not as a finished building, but as a lodestar, a navigational star.
Okay, I like that analogy.
It provides the strict mathematical framework, the scrutiny tests, the notice requirements that you, as a future lawyer, will use to hold the system accountable.
The gap between the 1987 Constitution's promises and the 2026 HRW report's grim statistics isn't a reason to abandon the theory.
Exactly. It is the exact space where your career exists. That gap is where lawyers do their work.
Well said. Man, we've covered a tremendous amount of ground today. We started with the philosophy of Aristotle, dissecting the difference between procedural compliance and substantive justice.
We really went back to the roots.
We analyzed the absolute necessity of public notice in Tañada v. Tuvera because a secret law breaks the fundamental social contract.
Ignorantia legis non excusat.
We unpack the rigid four-part test of the Equal Protection Clause and how the Supreme Court uses varying levels of scrutiny to act as the constitutional umpire. And finally, we held those legal mechanisms up against the stark, objective reality of the 2026 Human Rights Watch report.
You know, the friction between theory and reality leaves us with a highly provocative concept to examine regarding how the legal system heals itself over time.
Oh, I like where this is going. What's the thought experiment?
Well, we touched briefly on the importance of stability in the law. Courts rely on stare decisis, the doctrine of relying on past precedents so that similar cases are decided consistently.
Right. Stability is a core component of the rule of law. People need to know the rules won't change overnight.
But here is the thought experiment to take with you. If the Supreme Court relies structurally on stare decisis, how can a legal system truly correct itself when some of its foundational precedents were forged during eras when fundamental human rights were actively ignored?
Oh, wow.
If the structural foundation has cracks, does the law occasionally need to purposefully break its own rules of stability to achieve true substantive justice?
That is a phenomenal question.
Yeah.
And that is exactly the kind of friction you need to be analyzing as you prepare for your exams. The law is not a static textbook. It is a complex, flawed, but incredibly powerful system that you are learning to navigate and hopefully eventually repair.
Absolutely.
If this deep dive gives you a clearer understanding of how these constitutional mechanisms actually operate, don't stop here. Hit subscribe, and be sure to check out the Free Bar Coaching website for an absolute goldmine of free law materials to help you master these concepts for your exams.
Good luck studying, everyone.
Until next time, keep questioning the rules of the game.